Some of you may have attended a talk that I've given on unfair prejudice before. It's something that I turn back to from time to time. It's become something of a series, not as popular a series as some of the programs that have been made bearing this sort of title. The aim of my talk is to give a refresher to those of you who practice in this area regularly and an introduction to those who do not. But then moving from that onto a more recent case law update and some of the cases where I think the law has moved on a little or there's greater clarity where previously perhaps things were not so clear. So we'll deal first of all with becoming, hopefully, as clear as you can be on what unfair prejudice looks like. And then really what I want to focus on more is the update and some of the recent cases in the area. So first of all, an unfair prejudice claim is one of three of the main types of minority shareholder claims. The other two being a derivative claim and a winding up petition claim. All of them now statute-based. A derivative claim in particular, in my view, not used as frequently as perhaps it could be. My talk focuses on the unfair prejudice claim, but in order to understand what it is, you also need to understand what it isn't. The claims overlap. Often they involve breach of duty by directors. Often they involve allegations of unfair type behaviours. A derivative claim can only be brought with the permission of the court. And key in my view to understand when you're looking at a derivative type claim as opposed to an unfair prejudice type claim is in a derivative claim what you're seeking is corporate relief, almost always, i.e. at the end of that claim a payment or some other kind of remedy for the company. In an unfair prejudice petition, the remedy that is most often sought is a shareholder buyout order, and therefore an individual remedy for the individual shareholder who is bringing the claim. And that can be either that their shares are bought out, or in slightly lesser frequent occasions, that they buy out the shares of the party that they say has wronged them. Another distinction is that unfair prejudice claims undoubtedly can cover wider territory than derivative claims, because what is fair and unfair is engaged, obviously, in an unfair prejudice claim, but that is harder to run as a derivative claim. You've got the case of Frambar Holdings, a case from back in 2008, but one which I use when I get landing on my desk, a case where what's being sought is minority shareholder remedy for the shareholder. In that case, permission to bring a derivative claim was refused because what was really being sought was an unfair prejudice remedy. And so that case can be used both ways because it's a pretty clear example of what you should be doing. If you want corporate relief derivative claim, so if someone turns up trying to bring a derivative claim but seeking, for example, a share buyout, highly likely that you've got a good argument that they shouldn't get permission. Equally, if you have someone bring an unfair prejudice petition and what they're really wanting to do is bring a claim for the company, whilst occasionally you can seek as one of your remedies in an unfair prejudice petition the right to bring a derivative claim, generally that's a good sign that you're not looking at an unfair prejudice claim, and you should certainly first of all be looking at a derivative claim, because if you bring it as one of your remedies to the petition, you've got a very expensive route to travel before you get onto your derivative claim. The other type of claim, the winding up petition, is ultimately an insolvency-based remedy. And unfair prejudice claims is one of those areas where different areas of law collide. Previously, it was standard to plead as an alternative remedy the winding up of the company. That is now really heavily deprecated by the courts for obvious reasons. If a petition is brought seeking the winding up of a company on the basis of the remedy provided by the Insolvency Act, then creditors will potentially become significantly concerned about the future of that company. And an unfair prejudice petition in and of itself can cause significant problems with liquidity for the company. If you add on that additional limb, it's a bigger problem still. In light of that, the courts have produced practice directions saying you can only add that as one of the remedies for an unfair prejudice petition in circumstances where it is a definite remedy that is sought and there are real concerns about liquidity. The particular practice direction has moved around when CPR updates have been provided. The practice direction where you'd find it now is the insolvency practice direction at paragraph 22.1. If you are for a respondent to an unfair prejudice petition and someone adds that remedy as something that they seek, and the company is clearly solvent, you should be applying to strike that part of the petition out. It will get struck out in that situation in view of the practice direction. I realise having a barrister saying will is unusual. I am that confident about it. And you're highly likely to be getting costs on approaching an indemnity basis because the practice direction says don't do it. And so if you're doing it when the court guidance says don't do it, that's something which is likely to be considered to be unreasonable. You would add it if there's no realistic prospect of the company continuing, and what really needs to happen is the winding up of its affairs. Equally, you might bring it on its own. So unfair prejudice petition, more likely to be something where you're trying to breathe life back into a company that's been badly run, just an equitable winding up where really the company needs its last rites reading to it. In terms of the test itself, it's now section 994 of the Companies Act. Importantly for our purposes, and you'll see why in a moment in the update, subparagraph 1 tells us that in order to get an unfair prejudice petition through the courts, you've got to show that the company's affairs are being or have been conducted in an unfairly prejudicial manner to the member, or that a proposed act or omission by the company would cause that effect. And so in order to bring your petition, you need to be a member. A member is a current shareholder. It can include someone to whom shares have been transferred but who hasn't yet been registered, for obvious reasons where directors are doing something that is designed to shut out shareholders. They may seek to not register their shareholdings. It can also be someone who is a member by operation of law, for example, someone who is inheriting those shares through a will. That gives another reason that you might occasionally look towards a just and equitable winding up petition, because to bring one of those petitions, you do not have to be a current member. You have to have been a member for 6 months in the previous 18 months. So if your client comes to you and gives you what is on the face of it a really clear unfair prejudice claim, but they're no longer a shareholder, if they have been for 6 months in the previous 18, you may be able to find a remedy that they could use which otherwise would be unavailable through unfair prejudice. The Act now includes one example of definite unfair prejudice, which is divergence of opinion between auditor and company, where the auditor is removed on the basis of that divergence of opinion. So in terms of what the test means, it's an objective test. The case that I use to make that clear, if I need to, is Re-Bovey Hotel Ventures Limited, an old case that bizarrely is not given a neutral citation, but is cited time after time in the authorities because it's such a clear exposition of the law. It's said in that test that the test is whether a reasonable bystander observing the consequences of their conduct would regard it as having unfairly prejudiced the petitioner's interests. So what the particular directors or sometimes majority shareholders controlling the company think is not necessarily the most important thing. What would it be reasonable for them to have thought when taking those actions or proposing those actions? In terms of what you look to for what's unfair and what's prejudicial, Your starting point is the Articles of Association and the shareholder agreements, if there are any of the company. Look for breach of them. Look for breach of directors' duties. But in some companies, what we've been taught by the courts is that you look for equitable considerations that may mean that you can get further into the concept of fairness, where someone's pride may have been affected. In order for that to happen, you need the company to have decided that it should be run in a slightly more loose way apart from its written agreements that are the basis upon which it would expect to be run. In the seminal case of O'Neill and Phillips, Lord Hoffman, who handed down near all the most important judgments in this area, explained that the way that you understand that is first that when a company is formed, effectively the parties, the members agree, almost akin to a contract, the way in which that company should be run. And thereafter, in certain companies, the partnership type understanding that companies or indeed relationships between two partners would be run on the basis of good faith come to bear. Where equitable considerations demonstrate that the parties intended that the good faith obligation would be present, and potentially where the family decided that eventually they would incorporate the partnership that they'd traded for years for potentially tax-efficient reasons, and they all still met round the family table and discussed matters and decided things in that way, those kind of equitable considerations could mean that when, notwithstanding the fact the articles allowed one of those family members to be ostracised, to be removed as a director and, say, employee because they still held shares, that would be unfair prejudice. So in order to move away from the written documents, you look towards the equitable considerations. Now, Re-Guide Zone is a case where, at that time, Mr. Justice Parker tried to explain these concepts, and I find it really helpful, because what he said was that equitable considerations involve both the existence of agreements and understandings, i.e. ones that sit outside what's in writing at the time of incorporation of the company, and then detrimental reliance on those agreements and understandings by the minority. At that time, an equitable consideration may mean that you get the kind of system of operation of a company under which you step outside what's in writing. Now, in truth, to all of us in the room, that sounds like an estoppel, a set of agreements that are the basis upon which someone operates, to which they rely to their detriment. So if you can establish, and the way that I think about it when I'm pleading a petition, if you can establish a set of agreements, oral agreements, if you like, detrimental reliance, you're far more likely to be establishing a equitable consideration type case. And in those types of cases, whether or not a duty of good faith exists is in play, which would not otherwise be in play when you're looking at a straightforward shareholders agreement. And establishing a breach of a duty of good faith through unfair conduct is often much easier than having an argument about whether or not a shareholder agreement has been breached. Moving beyond that, it's important to know that the two terms are disjunctive. You can't succeed in an unfair prejudice petition with just unfair conduct, and you can't succeed with just prejudicial conduct. And an example that I give is the Rock Nominees case, where I think it was the Court of Appeal said that the directors had acted in hopeless conflict of interest when they'd agreed a transaction for the company by which it had divested itself of some assets. But the company had received good value for those assets. So notwithstanding that the conduct was unfair, there was no prejudice because there was good value. Petition failed. I've given you the quite recent quote from the judgment of Loveridge and Loveridge, where Lord Justice Floyd gave what, in my view, is the most helpful summary of what to look for in an unfair prejudice petition type case that's been handed down in some time. First, acts or omissions of which the petitioner complains must consist of the conduct of affairs of the company coming back to the fact that it's rooted in prejudicial conduct or affairs of the company. Second, they must have caused prejudice to the interests of the petitioner as a shareholder. You've got to be a shareholder to bring one, and it has to be your interests that are affected as well as any other class. Third, the prejudice has to be unfair. In truth, if you've got to the point that you're demonstrating prejudice that's affected you in a negative way as well as others, it's quite likely you'll establish unfair. Fourth, you can't complain of conduct which is in accordance with the company's constitution unless you can establish a breach of the rules on which it was agreed the affairs of the company should be conducted. Equitable considerations. And last of all, reference to a line of cases that went down using the term legitimate expectation instead of equitable considerations that resulted in problems. But I don't have time today to go into that particular route of folly that the courts fell into some time ago. You have a series of examples of the types of cases that are unfair prejudice type cases. Common ones are removal of someone as a director and employee, particularly in a quasi-partnership type case, misuse of companies' assets, divesting companies' assets, excessive remuneration, the other side of excessive remuneration being dividends provided on an unequal basis. But the examples are there for you to have a look at. And so moving on from that relatively quick intro onto an update. The first types of cases that I want to look at are the conduct that is covered by petitions, because it is a real problem area potentially. The first case is the King and King's Solution Group Limited case. The facts are not as important as the principles that come from that case. And the judge in the case was Lord Justice Snowden, our former Vice-Chancellor. In that case, Mr. and Mrs. King had brought a lot of different proceedings, but they included an unfair prejudice petition. And there had been an application to strike out parts of the claim because what was included in the petition were allegations of poor personal conduct that wasn't clearly linked to the conduct of the affairs of the company, i.e., I, shareholder, have been wronged by you, shareholder, rather than I, shareholder, have been wronged by the way in which the company is being run by you. And Lord Justice Snowden held that a case called Graham and Every continued to be of effect, and that what it meant was two important things. First of all, there has to be a causal connection between the personal actions of a shareholder, if that's what's being complained of, and some act or omission that constitutes conduct of the company's affairs in a prejudicial manner. And second of all, and possibly even more importantly, those actions and the link to the conduct of the company's affairs must be pleaded. If the petition does not clearly show why poor behaviour as between two shareholders is linked to the conduct of the affairs of the company, those parts of the petition stand to be struck out. And that's what the Court of Appeal decided should happen in that case. Now, because of that, there has been much greater focus on petitions issued after that date. And so in Brierley and Howe, you had a petitioner who had worked for the company initially without any shares. She'd then been given a 10% shareholding, and she alleged that her personal agreement with the founder and at one time 100%, now 90% shareholder, was that her shareholding would go up to a 50% shareholding over time. That was a personal agreement as between them. It didn't affect the conduct of the affairs of the company, and so her unfair prejudice claim was struck out because it didn't satisfy the Section 994 test that it has to be the conduct of the affairs of the company that are prejudicial, and there was no pleading of that link. And so the key takeaway from those cases is you can't just plead disagreements between shareholders in an unfair prejudice petition. You must link them to why you say that demonstrates prejudicial conduct of the affairs of a company. And if you are for a respondent and you spot that, apply to strike it out. Moving on to a case involving Cardiff City Football Club. I suspect many of you in the room will have heard of Vincent Tan and his ill-fated decision to try and make Cardiff City play in red rather than the blue that they have played in for years and years and years. Now they are back in blue. Mr. Tan is still the majority shareholder in Cardiff City, and the allegation in this case was that he had orchestrated an offer of shares which had the effect of diluting the minority shareholder, Mr. Isaac's shareholding. And that was undoubtedly at least part of his purpose. So in terms of his aims, they were unfair and they were prejudicial to Mr. Isaac. Mr. Isaac brought an unfair prejudice petition. The problem for Mr. Isaac was Mr. Tan isn't a director of the company. Mr. Tan was owed £67 million. Well, in fact, I think he was owed more than £67 million, but the deal that was struck for the share offer was that he would write off £67 million worth of debt the club owed him. And so the directors had formed the view that that was a good deal for the company. You can see why. And so notwithstanding the fact that Mr. Tan's motivation was almost certainly a malign one, because it has to be the conduct of the affairs of the company that is causing the prejudice, the case failed. And it even failed in circumstances where one of the directors was Mr. Tan's pal, and he knew of Mr. Tan's aims, and he was partly motivated by trying to achieve those aims. But because if a reasonable company director had turned their mind to the transaction, and even in that director's mind, part of it was considered as being in the best interests of the company, and that was a reasonable decision, prejudice wasn't made out. It was a reasonable thing for the company to have done, and therefore Mr. Isaac was left with a diluted shareholding. Moving to offers, many of you who practice in this area will be familiar with the idea that you may be able to prevent a petition if you can make an offer with no discount for minority shareholding, where you have an independent valuer, where they have equal access from both parties to that valuer to ensure that they are able to come up with what is a fair value for the shares. In the case of Elite Motors, there had been two brothers running a motor repair business as co-directors. One allegedly excluded the other and paid unequal dividends. Petition provided, but only after a fair offer had been made. It wasn't struck out, and the reason it wasn't struck out was because bolted onto the claim was a claim in relation to the unfair dividends and other factual disputes. And what was held was the court was going to need to resolve those factual disputes and the unfair dividends issue. The court was best placed to resolve that rather than any expert. And so on that occasion, notwithstanding what appeared to be an O'Neill and Phillips compliant fair offer, the petition shouldn't be struck out. So, tactics. If you're bringing a petition where someone's made on the face of it a fair offer, but your client's determined to bring one anyway, it might be a good idea to seek a remedy that is not only the shareholding. If you're the respondent and someone's seeking something else, it would be a good idea to think carefully about how you can include that in any offer that you make pre-issue. Conduct after the event and re-Audas group. Here, there was, I think for our purposes and given the time, there was clearly unfairly prejudicial conduct. The petitioner subject to that conduct had very clearly misbehaved themselves. The respondents said when the petitioner had emailed the company bank and attached confidential information to the email expressing concerns about the financial position of the companies in the group, he disentitled himself to fair value for his shares. The argument being that that meant he should not get no discount for minority shareholding type buyout. And the court held that although there was poor conduct post unfair prejudice, that didn't mean that the petitioner should transfer their shares at nominal value, because his conduct had been prompted by the respondent's own breaches of their contractual duties of good faith and the other unfairly prejudicial acts that they had visited upon the petitioner. So when advising our clients about post-unfair prejudice, prejudicial conduct, we need to be very careful about whether that conduct is very clearly caused by the unfairly prejudicial conduct and the level at which that conduct is at. If it's bad but relatively minor, it looks like the courts are unlikely to take that into account in giving a lower remedy. Re Stratos Club Limited is a case involving lots of the issues that can arise in an unfair prejudice type claim. The case concerns a lap dancing club in London called Sophisticats. The petitioner, Mrs. Langer, was originally one of 3 shareholders in a club in Marylebone. Her former husband was one of the other shareholders, and another, Mr. McKeown, was the third. From the inception of Stratos Club, Mrs. Langer had a 25% shareholding. The club in Marylebone obtained a second club in Soho with the intention that Sophisticats would then trade from both. At approximately that time in 2018, Mrs. Langer's former husband sold his shares to Mr. McKeown, leaving Mr. McKeown with a 75% shareholding. He became the majority shareholder, Mrs. Langer continuing to be the 25%. Shortly after that share transfer, in 2018, in the middle of the year, the Soho Club was sold to a company that Mr. McKeown held for £10,000. The problem with that was that Stratos had acquired that club for £620,000 and had spent £80,000 on it. The company had begun trading from it and at that time was making a loss, but clearly had invested very substantial amounts of money in the club with a view to it becoming profitable. And you might think, and certainly I do, and so did the judge, that was not a terribly subtle undervalue in the sale. Shortly after that, the lease of the Marylebone Club was up in 2019. And again, at that time, Mr. McKeown had acquired another club in Euston. That had been acquired through another different company. And he transferred the business of the Marylebone Club, together with the brand Sophisticats, to that company, leaving Stratos with nothing. Unsurprisingly, Mrs. Langer was not very impressed with this conduct, and she brought an unfair prejudice petition. Clearly, Mr. McKeown had diverted business opportunities to himself. He'd acted in conflict of interest, both in relation to the sale of the Soho Club and also in the acquisition of and then the transfer of business to the Euston Club, because, of course, as a director, you owe a duty to let your company know about business opportunities that come to you in that guise. And he didn't do that. He set up a different company, which he used to buy the Euston Club. Now, clearly, that unfair and indeed prejudicial conduct did relate to the affairs of Stratos. It did prejudice the petitioner, Mrs. Lawson. Her shareholding was substantially devalued. It was said by the judge that in June 2018, Stratos had 2 business premises from which it was trading. But by February 2019, the company was an empty shell. There were other elements of unfairly prejudicial conduct alleged which succeeded, including that a loan account was called in a way that was improper and prejudicial, together with other aspects, more minor aspects of mismanagement. Importantly, in going back to post-petition poor conduct, it was also suggested in this case that the petitioner's poor conduct meant that the discretion to grant an award, that being the purchase of her shares, should not be exercised. And her poor conduct had allegedly ranged from drinking and taking drugs in the club through to passing on confidential information. So a fairly wide range of negative behaviours, some of which could have damaged the company's fair bit. The judgment is very helpful in terms of what to look to when trying to work out where on the spectrum you need to get to for that type of conduct to mean that you come up with a different type of valuation. What was said is there must either be a strong connection between the conduct in question and the matters which the petitioner complains of, or the conduct must be so egregious that when it's weighed against the unfairly prejudicial conduct complained of, it affects the assessment of unfairness in itself, i.e. your conduct is so bad that in context what you're complaining about cannot properly be viewed as unfairly prejudicial conduct leading to the discretion being exercised. Given the way that these companies had come about, the company Stratos had been formed between her former husband, who was very good friends with Mr. McKeown, and his wife at that time, Mrs. Langer. And the degree of trust and confidence that had been posed as between them, and indeed from the 75% shareholding by Mrs. Langer and Mr. McKeown to run that property, run the two premises properly, and indeed the business properly, a quasi-partnership was established. Notions of good faith were engaged, unfairly prejudicial conduct made out, and the appropriate remedy was held to be a share purchase with no discount for minority shareholding. It's now well established that the presumption in all cases, and this can be a barter settlement, but the presumption in all cases is no discount, minority shareholding or otherwise. You need conduct that is outside the norm to get away from the no discount for minority shareholding approach. The flexibility of the Section 994 remedy was very clear because the valuation date that was chosen was the date when the Euston Club was purchased, i.e. the second additional club, and on the basis that the Soho Club had been sold, so the first one that was sold for 10,000, at proper value in an arm's length transaction with a license to use the Sophisticats brand. And so the accountants were going to have to go away and provide expert evidence as to what that value would have been that would have come into the company, and then what the valuation of a business that had two premises back in June 2018 was. So the share purchase was going to be at a very different price to the price reflected by the empty shell that confronted the court as at February 2019. And so, as I say, if you need a refresher of the types of issues that come up in unfair prejudice petitions and the way in which the court is likely to resolve them, Re Stratos is a very good place to start.